Welcome back, everyone, and thank you for sticking with us, those of you here in North America, possibly even Europe. And welcome and good morning to those of you from East Asia who will be joining us on this panel. We're really extremely grateful, gone above and beyond the call of duty to wake up at, I think, 7 a.m. On a Saturday morning in Beijing and Singapore. So for this panel, we will begin with Professor Yifeng Chen from Beijing University Law School, and then move on to Simon Chesterman, who is Dean of the National University of Singapore Faculty of Law, followed by Greg Shaffer, who is the Chancellor's Professor at the University of California, Irvine. So, Yifeng, I just want to see if you're there.
Yes, I'm here.
Yes, he is. And thanks again, and I will turn the floor over to you.
Thank you, Tom. It's a great pleasure to join the discussion. And today I would like to address the social science, the relationship between social science approach to international and its relation to international law. I think the social science approach to international law as advocated in the paper is to be based on rigorous fact-based empirical research. And it is very relevant. I think it is especially relevant in the context of the United States, where international law is often considered to be indeterminate or irrelevant. So I think skepticism is a healthy attitude towards international law's normativity, and to facing squarely the reality of the world is also important. The law's effect cannot be assumed, and states do not necessarily collaborate with each other, and multilateralism is not a natural choice for the states. And the empirical research would be very useful to help international lawyers to face those issues. And it is also important for the international lawyers to be aware that intervention by law do not necessarily bring the outcome or effect that we have in mind. And these are the questions that international lawyers should be facing straightforward. And I think this is very relevant. And my first point I would like to say is that I would emphasize the traditional international scholarship also has a very strong scientificism trend. And it is also trying to make international law as close as possible towards state practice. This is also very important, and I would say this is the social science tradition within international law. And this is reflected as the positivism arising from late 19th century. And this is can also be seen from the requirement of concreteness when international lawyers constructing rules of international law. And we have even seen the attitude of apology towards the behavior of great powers. And these efforts are trying to make international law as not purely utopia. And international law has its own sociology to make the rules seems plausible. And I could take customary international law as an example. And state practice and European juris are considered two elements of customary international law. And when it comes to state practice, it is generally agreed that extensive, virtually uniform, or widespread and represented practice is required for the constitution of customary international law. And it is also emphasized that specifically affected states should be given special consideration when we're elaborating on customary international law. It is also emphasized that the physical acts would give more weight in practice than the verbal acts. And we also given role to the persistent objectors. I think all these arrangements are trying to give role to the idea that the international society is state-centered, decentralized, and without a strong enforcement mechanism. But even for this sociology, there is also full practice, full of choice and constructions. And it is a process both for the infusion of idea and also in the process of the formulation of norms and order. So in this sense, international law is truly a subjective and uncertain process. I could give you two concrete examples. One example is related to the determination about the breadth of the territorial sea. By the conclusion of 1958 Territorial Sea Convention, there are two different practices, two strands of practice among states when it comes to breadth of the territorial sea. There are more than 100 states using 12 nautical miles standard, and the remaining country using 3 nautical miles. And the practice is inconsistent. Then we have to make a judgment what would be the valid international law. And three options are open to us. First, there could be no customary international law as state practice is not consistent. The second option would to assert that 3 nautical miles would be the customary rules of international law, and this is the breadth without controversy. And the third option is, of course, to assert that the valid rule would be 12 nautical miles, because those countries who draw 12 nautical miles have not received opposition from other states. So all the options are possible, and then it is for international lawyers to draw the decision where we would which choice option we would like to take. So the facts are always open to interpretation, and the uncertainty is inherent in construction of international law rules. The second case I would like to refer to is the judgment made by the International Court of Justice in its judgment on the jurisdictional immunities of states between Germany and Italy. The case concerned the state immunity of a state for its conduct of the military force during the Second World War. The court eventually gave the rigid opinion that the state should enjoy state immunity before the civil proceedings of another state, even for acts that lead to death, personal injury, or damage in the conduct of armed conflict. And this court reached that conclusion by starting with an assumption that the international law principle of sovereign equality would make the state immunity necessary and important. So, and according to the court, the exception to immunity of state represents departure from principle of sovereignty. And the court further states that the parties were in broad agreement regarding the validity and importance of state immunity as part of customary international law. The court tried to construct the dispute as a difference as to whether the law to be applied in the specific case. And if we look at the practice that the court has examined, it is fully possible for the court to reach a different conclusion. So the critique on the indeterminacy of international law is correct. Traditional international law try to use objectivity and certainty to construct its legitimacy and internal validity. It also tries to present the knowledge in a scientific, objective, and certain way. This kind of international law theory should also go through demystification. And it is useful to highlight those premise that of the traditional international law approach. For example, it conceives the international law as court-centered. It assumes the meaning of the norm is definitely clear and ascertainable, and it assumes the universality of international law. It further assumes that states would be prone to international collaboration and multilateralism. The cost of enforcement and making international law is neglectable. And all these assumptions should be made to the forefront for us to better understand the traditional approach to international law. And more than those assumptions, traditional international law also has its own ideologies. It is state-centered, rule-based, and dominated usually by great powers. And it has to a certain extent, it tries to conceal certain elements in our discourse. For example, what would make state practice, and by what threshold we could reach the conclusion that customary international law it comes into existence. And these were clearly considered to be judicial craft and not subject to open discussion. And I think it is very useful for us to relocate those background assumptions to the forefront and to conduct open discussions about those social science ideas underlying the normative projects of international law. Now I'd like to get back to the social science approach advocated by Adam Chilton, Tom Ginsburg, and Daniel Abebe. I think one should note that the social science approach suggested by the paper is prominently associated with positivism, which has its own philosophical and methodological constraint. I think skepticism is healthy and relevant. Often legalization is but one of many options. International Labor Convention may not necessarily promote the protection of workers. And the question is whether the social science approach help to resolve or respond to those issues. I think there are several limits inherent in the social science approach. The first of all, I think the social science approach is also politically informed as the legal study in general. However seemingly neutral and objective, subjectivity remains an essential part to social science research, as the authors have recognized by themselves in defining the questions, setting the context, identifying the variables, relating the variables as cause and consequence, collecting and interpreting the data, establishing the causal link, generalizing the research outcome, are all subjective and in a sense, political choice to be made. So I would say the second, I think the measurement, identification, and theoretical construction constitute the social intervention themselves. And they, by these interventions, they also make the world. The preference and value judgment is not only internal, but it also constitutes what is. And it, in assuming what is being, what's the fact, what's the reality, these are often depending on our perspective. And another inherent danger in here is that it might restate or reconsolidate existing structure and order by looking at what is the facts and by giving the facts the normative weight in the social science approach. So I would say that the social science approach tries to use another objective knowledge to replace the traditional objective knowledge approach of the traditional international law. As the article has suggested, it is a modernist perspective of knowledge. And I think there is limits here. So I would like to then share my understanding about international law. I think international law should probably not stop here. International research should not stop by social science approach, and we probably need to move a bit further. If we consider international law as a viable project for social reform and for achieving international justice, then the social science approach might appear to be too reductionist. It could reduce the international law into administrative vocabulary and without giving full weight to the constitutional dimension of international law. And we should think more deeply about the social science of international law. And I think it will be very useful to, for example, to introduce the attribution and causation mechanism into international law. And all these mechanisms are actually institutions for social distribution and redistribution. And many of those causation links may be remote and may not be directly observable. For example, when it comes to poverty, would we attribute to the corruption of the local government? Or are we going to attribute it to the lack of property mechanism or lack of marketization? Or are we attributed that to their role in the global economic, political economic system? And all these attribution or causation understanding would determine what kind of international law measures that we would take. So I think these are different. There are different possibilities to see the relationship between law, politics, and science. And to conclude my observation, I think a modest, self-reflective social science approach is useful. And it is useful not in the sense it provides objective knowledge, but in the sense that it offers very useful and healthy dialogue between different approach and perspective to international law, without assuming any method as the only correct way or the superior way of doing international law. And international law could be seen as in social science by itself. International law constantly oscillates between faith, normativity, theology, and practice, idea, and science. And I think international law may constitute a distinct normative expression of the sociology and teleology of the international society. And these words I'd like to conclude my reflection, and thank you.
Thank you very much, Professor Chen, for that terrific presentation. Brilliant. And apologies for my audio problem, which was my problem, not yours. So without further ado, we'll move south in the same time zone to Dean Simon Chesterman from Singapore. Good morning, Simon.
Good afternoon, good evening, and good morning indeed from Singapore. And I apologize for missing the discussion up to now. I did have a quick look at the Twitter thread, which suggests there's been a rich discussion, but sorry for just joining it now. But greetings from the future. It's already the weekend here in Singapore, something for all of you to look forward to. And it was a great pleasure to be sharing a panel with Chen Jiaoshuo, Professor Chen, who I think was more polite perhaps than I will be in expressing some of the concerns about the social science approach. But I think there will be echoes in what he was saying in, if you like, a narrower frame of the positivist conception of international law, the development of customary international law, and what I'll say about the subject more generally. Now, just to provide a bit of context, I'll put up a presentation just to partly to keep myself on track. It's the reason I took this call on a Saturday morning is this is a fascinating topic and great people involved. So again, thank you for involving me. And I took it also because the subject of international law has always struggled to be taken seriously. And this is something that I think international lawyers grapple with more than many other disciplines, which is something I'll return to at the very end. Much of that struggle has been over the status of international law as quote-unquote law. So HLA Hart prominently critiqued it, and many others have expressed serious reservations about such a claim, in particular those from the realist tradition of international relations. Now, my former supervisor, Ian Brownlee, the late Ian Brownlee, had an innovative way of answering this question. When someone asked him whether international law really was law, he would say, well, that's my Bentley parked outside and I'm an international lawyer, so it works for me. Not necessarily the best response, but it worked for him, as he said. More recently, Anthea Roberts has questioned the extent to which international law can really claim to be quote-unquote international, given divergences in the way it's taught and understood around the world. And indeed, that's something we might discuss with regard to how international law is discussed in the United States, as opposed to, for example, where Professor Chen is in China. But for today's purposes, Adam, Tom, and Daniel are raising an eyebrow as to whether international law even deserves to be considered a subject in the academic sense, proposing that this would be bolstered through recognizing and expanding the social science methods described in their article. Such an approach will, they argue, produce research that is more normatively restrained, empirically informed, and more skeptical, by which I assume they mean better. Now, this presentation and the essay that I'm doing for the journal will push back against these explicit and implicit claims in two ways. First, analytically, second, politically. And I'm doing all this partly seriously and partly slightly exaggerated to get a response in the last session of a long conference. And I'll conclude with an explanation of my somewhat labored metaphorical title. So on to part one, the project of international law. So Chilton, Ginsburg, and Abebe's argument is at its core about method. The solution proffered to solve the perceived problem is the tried and tested methods of social science. And an important part of their critique is that this should be done in an external manner, similar to other subjects of social scientific research. And I would put it to you that this is an elegant answer to the wrong question, because international law is not like other subjects of social scientific research for one and a half reasons. The half reason, which is not really a compelling one, is that international law, its study and its practice, has always had an undercurrent of idealism. International law and international lawyers have always conflated the is and the ought. Anyone who's taught international law knows the experience of having to explain to students that real-world suffering may not be addressed by international law remedies. I remember the first feedback I got when I taught my first course on international law at CEPA at Columbia. And these students said, yeah, well, Chesterman's an okay teacher, but he really hates the United Nations, because I wouldn't agree with them that there were remedies for all the wrongs that these idealistic students were identifying. As I noted, this is not a good reason, and we academics ourselves are not immune to the desire to make international law better. Indeed, this idealism has often encouraged overstretch, and the paper will recount two examples. I'll talk about humanitarian intervention and about the discourse on business and human rights, which coincidentally was the subject of my last article in the Chicago Journal of International Law. Both of these discourses in the 1990s displayed a certain irrational exuberance about the possibilities of what international law could achieve. This may sound like special pleading for international law, and to some extent, of course, it is. But the better reason that international law academics have always been, the better reason is that international law academics have always been participants in, rather than mere observers in our field. And this is partly because our subject matter is incomplete. There are lacunae, and Professor Chen was highlighting that with regard to the evolution of the territorial sea. A former Canadian foreign minister had an easy way to remember or describe this, which is that he used to say that international law and law are like the relationship between cheese and Swiss cheese, similar substance but lots of holes. Now, nature and the academy abhor a vacuum, so academics fill this uncertainty. There is, as we know, a normative basis for this. The International Court of Justice's statute itself lists as a subsidiary source of international law the writings of the most highly qualified publicists of the various nations. And now, international lawyers, like professors everywhere, we have an overinflated sense of our importance. In one survey of law academics, fully 90% said that they were above average teachers. And among international lawyers, I think we all believe ourselves to be the most highly qualified publicists. But from Grotius's Battle of the Books to modern lawfare, to indeed the arguments over the territorial sea, international law has always provided scope for academics to be advocates as well as analysts. Now, this is an unashamedly internal view of international law. Chilton, Ginsburg, and Abebe allow for this, noting that international law scholarship has played a particularly prominent, or they seem to be saying surprisingly prominent, role. But they're called to abandon labels, to avoid committing oneself to any assumptions, theories, or philosophies beyond those required of any other social science researcher, presumes the ability to be a truly external observer. Now, some postmodernists and post-structuralists have made the strong claim that this is impossible in any circumstances. Here, I'll confine myself to the more modest claim that in the context of international law, the role that academics have played and continue to play in constructing the discourse makes that dispassionate and disinterested claim dubious. So a second reason to push back against this social science manifesto is that in addition to being analytically questionable, it's normatively undesirable. And the reason for this is that the project of international law remains an unfinished one. If Oppenheim had been successful in his call for international lawyers to embrace a scientific method a century ago, few of the advances that I talk about in the earlier section of the paper would have happened. Oppenheim acknowledged, of course, that international law was a work in progress, but he said that there were limits. The international jurist, he said, must not walk in the clouds. He, or she, we might add, must remain on the ground of what is realizable and tangible. It's better for international law to remain stationary than to fall in the hands of impetuous and hot-headed reformers. Once more, Chilton, Ginsburg, and Abebe are aware of this role. They are aware of this, and they devote a whole paragraph each to feminism and twale. And we might argue whether that's enough. They might respond that these are simply different projects. I'm writing or coming from an unashamedly internal angle. Their approach is external. And indeed, this whole panel is framed as an internal view. But the permeability of these borders is, I would submit, important. The social scientists Chilton, Ginsburg, and Abebe argue is engaged in a positive enterprise of trying to engage the world as it is, rather than how it should be. But taking international law as it is a normative position, and in a different way from the maximalist claim that that is true of everything in the world. Because the international law academic, more I would argue than perhaps any other discipline, has the potential to affect the subject matter of the study. We are not scientists merely observing the phenomena around us. We're not Starfleet officers observing some prime directive of non-interference. And when, in a domestic context, Chief Justice Roberts claimed in his confirmation hearings memorably that his job as a judge was merely to call balls and strikes, knowing pundits rolled their eyes. That was in the domestic context. No serious International Court of Justice judge would be foolish enough to make such a sporting analogy. Or if they did, they might say that their job is to call balls and strikes while also negotiating on a daily basis where the strike zone was. Stipulating in particular a measure of objectivity does not dispense with partiality and partisanship, it merely masks it. So, about those cats, and this brings me finally to the laboured double metaphor of my title. Herding cats is, of course, the cliche that points to the difficulty, some would say the futility, of controlling or organising entities that are inherently uncontrollable. States manifestly are not cats. And if I can offer a quick note to the editors of the Chicago Journal of International Law, I'm hoping I won't have to provide a footnote for that claim. Nonetheless, like cats, the respect that states hold for authority is episodic at best, and when they do not get their way, they may hiss, they may spit, and they may draw their claws. Schrödinger, of course, is in turn a reference to the famous thought experiment in which a cat, somehow having been herded into a box, can be both alive and dead due to its fate being tied to a random subatomic event, and only when the box is opened will the cat's fate be revealed or resolved. In the same way, the status of many international law questions, more so, I would argue, than most phenomena, including human phenomena, remain ambiguous until they are studied. Indeed, some would argue that they can remain ambiguous. Now, the late, great Tom Frank, writing on the question of humanitarian intervention, once observed that sometimes such conduct is lawful, sometimes it isn't, and sometimes it both is and isn't. Now, I happen to disagree with Tom about that one, but his point about legal indeterminacy, the lacunae of which I spoke earlier, runs through much of modern international law. This, then, is the more serious criticism of the turn to empiricism in international legal scholarship, exemplified by this symposium, that it risks reducing some of the most interesting questions to yes and no answers or to problems of coding. The paper that we're discussing essentially concedes this with the example of ongoing debates over the effectiveness of international human rights agreements. Such approaches are useful and effective when facts can be ascertained and when it's possible to maintain an aversion to normative commitments. But if one concedes that, for most of the interesting questions in international law, facts are contested and determining norms is half the game, if one concedes that the cat could be either alive or dead or somewhere in between, then social science methods alone may not be the answer. So to end where I began, the subject of international law itself has always been ambivalent about its own status. I struggle to think of a discipline that has spent so much time and ink agonizing over the very words that should define it. The debate we're having is therefore as familiar as it is healthy. And moving forward, I fully expect to see more work taking up Chilton, Ginsburg, and Abebe's invitation to bring a social science approach to the study of international law. And I, for one, look forward to fighting against that. Thank you all very much for your attention.
Terrific. Thank you so much, Simon. Excellent gauntlet you've thrown down, which we'll return to after we hear from the great socio-legal scholar, Greg Shaffer.
Thanks for this. I think I'll inspired now by, in response to Simon, take a middle ground or try to take a middle ground. This is very much a work in progress. In fact, it's not really written, but it's part of it is what is the middle ground is taking is a sense of noting what's in common between internal and external approaches, something that I think Simon hinted at, by expanding the concept of what is a social science approach, and by embedding it in a theoretical framework that I've developed with Terry Halliday that studies the links between international law and national and local law and practice. So they're no longer binaries. Okay, so this this essay aims to elaborate in 3 ways the call for renewal of social science approaches to international law. First, while we affirm the importance of what Adam, Tom, and Daniel call the scientific method of hypothesis testing, we argue that it can and must be complemented by several other well-institutionalized social science approaches to international law. Second, we concede the links between internal approaches to international law by proposing that conceptualization and empirics are integral to both approaches. And third, we propose that the full promise of social science approaches to international law can only be realized when the international is held in dynamic tension with the national and the local. Okay, so first, just amplifying what is meant by a social science approach to international law beyond deductive reasoning in which hypotheses are developed and tested. There are clear advantages to such deductive approaches in terms of what they highlight. But while this aspect of social science engagement with law has many merits, we stress that a multiplicity of methods and theory comprise the richly textured promise of social science for the study and practice of international law. In part, the complementarity of other empirical approaches is necessary because frequently the most important questions cannot readily be reduced to quantitatively measurable variables. And even if they can, there's an absence of valid and reliable data on cross-sectional or time series studies. In part, this complementarity is necessary because the ability to produce a verifiable theory relies on prior stages of understanding, concept development, and hypothesis production, and likewise depends upon later types of empirical research to make meaning of the results that too often are conflicting, ambiguous, or lack in explanatory power. Hypothesis testing, therefore, is not the starting point nor the end point of social science work, but rather one important component of ways that social science can address law's relationship with society, politics, and the economy. The embeddedness of hypothesis testing in a wider, multifaceted enterprise of social science can be seen from the development of an extensive body of interdisciplinary scholarship in the past years on the normative development, rise, contestation, and fall of what Terry Halliday and I conceptualize as transnational legal ordering and transnational legal orders. We begin with a high-level concept of order with both processional ordering and institutional orders aspects of expressing this concept that could bring macro social science and legal frames to encompass the bewildering diversity of social problems in relation to law, regulation, and governance. Here we consciously displace exclusive focus on traditional conceptions of international law by situating international law within the frame of transnational legal ordering. We bring old concepts such as institutionalization and new ones such as recursivity to channel empirical research across and within conventionally defined subject areas of law. While we elaborate further elements of this genre of social science engagement with international law, suffice it to say that this phase of theory development owes more to a Weberian genre of social science research on law than to a particular genre of strict hypothesis testing in contexts where quantitative data are already available or can be easily constructed. It is a phase of inductive extrapolation and synthesis of concept development and invention, of proposals for encompassing theory that may offer frames, then propositions, and press ultimately towards specific hypotheses that may be tested. And in fact, in the first round of case studies using the TLO theoretical framework, we discovered scores of hypotheses, all susceptible to some form of historical, quantitative, or qualitative examination that can be pursued. Therefore, we contend that social science approaches importantly include framework construction, concept elaboration, as well as hypothesis generation and testing involving both deductive and inductive reasoning. The next, our second point is so to loosen the internal-external binary from the perspective of practice. So the authors of the framework essay contrast a long-standing distinction between, quote, internal views of international law, which are characterized by descriptive and normative or doctrinal analysis, and external approaches, which examine the law from the outside, how it came to be, and what are its consequences. Our own research indicates that it may be time to loosen this distinction from the perspective of actual practice. On the one hand, such loosening of this binary will constructively expand the contributions that social science can make to both external and internal legal questions. In addition, both internal and external approaches operate within particular social contexts and both conceptualize and aim to address perceived social problems in practice. For too long, sociologists and other social scientists treated the internal processes of lawmaking, and even more, the very in substance and form of international law itself, as a black box, a region of activity colonized by lawyers, and to be left to their exclusive epistemological claims. This separation of study suited the lawyers since it erected a fence around their mostly invisible doings. Our work aims in part to reveal how doctrinal development can be leveraged as instances of behavior subject to social science inquiry, extending a line of scholarship on the rhetorical properties of global norms and scripts. For example, Terry with Susan Bloch-Levis showed that the varieties of law produced by UNCITRAL, legislative guides, model laws, treaties, comprise a repertoire of rule types embedded in other rhetorical contexts, which reflected on the one side an adaptation to the political challenge of finding global consensus on legal norms, and on the other side, a prospective anticipation of what institutions, courts, executive agencies, and legislatures within states could accept as international normative guidance to bring national law into concordance with such global norms. In other words, internal actors were deeply interested in so-called external questions. Relatedly, through systemic interviewing, my work on the World Trade Organization, international trade law, shows how internal actors are equally interested in understanding the processes that I was studying, as they were themselves engaged in quasi-social scientific studies of the same processes. That is, they too wished to understand and respond to legal processes and the issues that they addressed. They too, in other words, were aiming to make sense of developments in the trade law world that I studied, as they must respond to a continuously unfolding present on partial information in real time. In a pragmatic logic, almost as strong as the should in normative law, a close examination of international law's doctrinal content and form can be posed by the social scientists as a contingent proposition. If actors want a given outcome as a pragmatic aim or normative ideal, what will be the substantive and formal properties of the law more likely to bring this about? This task is firmly within the epistemological mandate of both the social sciences and the internal participants in legal processes. So researching transnational legal orders and legal ordering, traditionally, international law focused predominantly on interstate relations. The scope of international law has expanded to cover most substantive areas of law, from human rights and criminal law to regulatory law and business transactions. The scale and parallel of international norm making swelled as actors aim to use international hard and soft law processes to reach deep into state law and institutions. So with Terry, we initially developed a framework on transnational legal orders, which emphasizes orders and ordering and brings an integrated socio-legal vocabulary and method to international law grounded in social science. Researchers begin, just as actors, by identifying how agents of legal change frame a problem to be solved by law, conceptually. A TLO, by definition, involves more than a codified body of international law. It must, in practice, exhibit perceptible concordance of legal norms among transnational, national, and local levels of lawmaking, which is the whole point of the UNCITAL processes, as well as in international trade law, on which I'll speak in a moment. Transnational legal orders, also we insist, are constantly in motion. They're rising, falling, adapting, dissolving, and recursive processes where legal change within a state or by a state can impel change in international law, just as change in international law can influence law reform by actors within states and local institutions. So the paper will try to exemplify this in both my work and Terry's work. I'll just, because of limitations on time, I'll say something about my forthcoming book, Emerging Economies in the World Trading System, the Past and Future of International Economic Law, which exemplifies how international trade law developed through recursive interaction between domestic and international law and practice. On the one hand, the United States had the greatest impact in shaping WTO norms. Many of its norms came out of US law and practice, ranging from intellectual property and import relief law to the timelines for WTO dispute settlement and the organizing principles for WTO negotiations. Other countries, such as Brazil, India, and China, which are the 3 case studies covered in the book, adapted their laws, institutions, and professions in light of WTO norms, and they did so dramatically. When they became adept at international trade law, however, they successfully challenged US practices and resisted US pressure on them, which helped catalyze US disenchantment with the very liberal economic order that it had been central in creating. This empirical study started with a problem: the role of trade law capacity in shaping legal norms and affecting outcomes. The work included a quantitative study based on an original survey of members' legal capacity and its implications, and systematic interviewing and participant observation over time. It traced the contribution of legal capacity to the settlement and the unsettlement of both national and international trade law norms and practices across these major countries, and their broader implications for the world trading system. So, in conclusion, we contend that law should no longer be studied in a methodologically nationalist perspective involving a sharp dichotomy of international and national norm development and practice as reflected in predominant internal and external scholarly approaches. Our framework holds the promise of substantially amplifying social science approaches to international law with the prospect of mutual enrichment. In so doing, it amplifies, we hope, the spirit and widens the scope of what Chilton, Ginsburg, and Abebe call for scholarship on international law enriched by social sciences. Thank you.
Thank you so much, Greg. That's terrific. And so now it is time for questions and comments, and I'm ready to start, and I'm sure Professor Chilton may have something to add. And of course, if you do have questions, just raise your hand or send a note to me through chat. So I'll just give my quick reactions. First of all, thank you again. It was a terrific discussion. And you cannot have known, Simon and Yifeng, how well that fit in and kind of wrapped up our day. Because we started with Nat Erie, I started talking about the is and the ought at the very outset of the day. So it's been a very nice way to finish the symposium. And I think I'm going to start with Greg's point about loosening the binary, which strikes me as quite right and very interesting way to do it. And I thought Yifeng actually gave us some ideas for how to do that. So how, you mentioned attribution and causation and sort of pockets of positive international law, which would actually benefit from integrating the social science approach. And I thought that was a valuable contribution to move us forward, very much so. All of you and all of us are aware that, positivist social science has its limits. No one is being naive here about that. But as I think about my own approach to this, and why I have taken the approach I have, and Adam can speak for himself, Daniel too. But we're just coming from a slightly different place, I think, than this idea that international lawyers are participants and observers. My own, thing which drives me the craziest is sort of the pure crit approach to international law, which of course we've all read and has informed some of the comments that both Simon and Yifeng made, which I think is even more guilty than us of bearing its normative assumptions, because it's just deconstructing stuff. And yet all of these folks do have very strong priors. So I feel like that's not really an answer, right? That particular angle. What is an answer, or what's required, is to be much more reflexive about our assumptions. The three of us are academics at the University of Chicago, and that's important context. This has been a global thing. We have people from Africa and China and Southeast Asia. And, the University of Chicago is a very academic place in a very academic culture. And in a way, we are somewhat, I don't want to say privileged, but we're relieved of the burden, which many international lawyers have, of having to be participants. We're not working for government. None of us work for the State Department. We're not trying to write things for US policy or anything like that. And in a way, that's liberating and allows us to take maybe more of an external perspective than the modal international lawyer, around the world. I want to tell a little story about Ian Brownlee, who I didn't know was Simon's advisor, if you don't mind. So when I was clerking at the Iran-US Tribunal, Ian Brownlee came to make an argument. And by the way, those students won't have heard his name, but he was a super famous international lawyer, wrote this keeper of one of the great treatises. And he came and he was making an argument before our tribunal. And it was an argument for Iran, and it was just a terrible argument. It was nothing. It was just an awful argument, but it was all he had. He was doing what he had to do. And one of the judges had his book and said, well, wait a minute, what you're saying completely contradicts your book here, your academic work. And Brownlee got very upset. It's as if someone had scratched his Rolls Royce or something. He was, how dare you? I've been an advocate for X years and I'm acting here as an advocate, as if it was somehow unfair to demand psychic integration across these two realms. So I think, if that's the move, if we could just take off one hat or another, and I think Oskanyemi does the same thing, I'm not sure that's so great either. I'm not sure that's a real answer to the question. At the end of the day, you guys missed Mary Ellen, and I don't know if she's still here, but she was sort of articulating a challenge to all of us by saying, natural law is where we should start, and social science has nothing to say about that. That's a product of human reason. And what's valuable about her approach is at least she's got her normative stuff out on the table. And then we can say, as Greg was sort of doing, like, okay, given this ends, what are the means? That is, and the way I said this at the outset, is you can't you can define an ought, but you can't really figure out what's feasible without without some sense of what's feasible. And Greg said that, I think, in his presentation. So I guess that's the way I react to Simon. In particular, the fact that we can't really ever be outside doesn't mean we get to throw up our hands and bury our assumptions either. And it doesn't really make me want to go like, oh, I'm wearing this hat, now I can make this argument. It's not attractive to me personally as the participant point of view. Adam, why don't you speak, give your reactions next?
Yeah, sure, great. So I think that both in, really the first two papers in this panel, and perhaps in Mary Ellen's presentation, a few of the others, there's a bit of a thread that suggests that perhaps that there's special features of international law that make it less susceptible or a less fruitful place for social science research than perhaps other areas of the law or of, legal phenomena more generally. And I sort of have the opposite approach or opposite view on whether or not this is true, and that I think that international law might need empirical work and social science work even more than other areas, right? So, for instance, if you take, I don't know, criminal law, so many scholars interested in figuring out, what's the effect of sentencing regimes on recidivism? Or in corporate law, what's the effect of staggered boards on corporate behavior or profits, or whatever it may be? Legal policy choices are just sort of filled with empirical trade-offs, and we try to measure what those trade-offs are to form the best policy. But in those areas, I think that there's a belief that the legal decisions that are made have consequences, and they will affect the incentives and the behaviors of the participants in these areas. With international law, in part due to the kinds of skepticism that Eric and Jack talked about when presenting their book, I think there is still a deep skepticism by many politicians, many leaders, et cetera, about the effectiveness of these regimes, what would work, what wouldn't work, et cetera. And in other words, the burden for evidence is even greater in international law. And so, to the extent that any field needs evidence on what works and doesn't work, I think we're at the front and not the back of the line right now. And so, to the extent that any of the arguments are unique to the idea that international law might be special in some way, I think all of the things what make it most unique are things that call for more empiricism. To hand off this train one more time, though, I had a question for Greg, which is, so along with Tom, as in this article we've mentioned a few times, that you guys documented the existence of what the sort of body of empirical legal scholarship was 8 or 10 years ago when you guys would have been putting this article together. I'm curious if you've noticed changes since then in the way that this has progressed, or has things sort of just been continuing as is in the last decade, the way that they were in the first decade?
Greg, do you want to take that direct
Sure.
question, and then we can also turn back to Simon and Yifeng.
So, we've heard some resistance today, but I think there's actually much greater acceptance within sort of the mainstream international law community of the value of empirical work than was certainly reflected, because Tom and I also started our article with the famous CJIL special issue on methods, which uses the term methodology without mentioning social science at all. Right? I mean, it's silent. And so I don't think that would happen anymore, or there'd be questioning about that, or there'd be more social science at least engaged in the essay. So I think there has been a shift. And maybe that's, in a sense, I think it's a good thing, because in some ways, I think it's a reflection of just the scope of and scale of international law today. Even though we talk about, clearly there's, depending on which area of it touches so many areas of social life. UNCITRAL is just on basic business norms, right? You can see it. There's so much norm making occurring at the international level, and there are domestic actors who are engaged in this, and they are playing in both fields at once. They're playing at the national level too, and these are tools for them because they're conflicts. It's not as if the idea that there's a state which has a defined interest. If one looks at that, then there's a much narrower scope of assessing international law. But once you sort of open up the state and you see who these actors are, and there's norm making contestation taking place both at the international level and within states, I think the empirics become much more interesting, and I think they're becoming much more accepted across in terms of the study of international law generally. I think you see this reflected when we did a study of CJIL, for example, and the study in the past publication of articles that actually used empirics. We found very, very little. Since we published that piece, you'll see a much larger number of social science studies published by the flagship journal. So.
Yeah, I'll just respond. And clearly, I was to some extent setting up a straw man argument. I don't think social science approaches are wicked or illegitimate, but I do think that I'm not sure I'd agree with Adam that it's more necessary, but I would argue that it's harder in international. And partly this goes back to my own sort of history of starting to go to International Studies Association meetings 20 years ago when I just finished a doctoral thesis on humanitarian intervention. and hearing these empirical analyses of humanitarian intervention in which the first 30 seconds where the coding was explained covered everything that I thought was interesting, and all the rest was just mathematics. And clearly that's a caricature of social science methods, but I think, and Mary Ellen, I think, has highlighted this in the chat, and I suspect I would agree with a lot of what she said earlier, that the danger with assuming that you are merely engaged in an analysis of a pre-existing phenomena in which facts can be ascertained. I think much of what I find at least interesting about international law is bound up in that sort of moment. And so a question that I'd sort of raise is whether this is really a question of disciplines and whether disciplinarity is relevant here. Because I studied international relations when I did a Bachelor of Arts as an undergraduate, and periodically through my career would find that it was useful to bring international relations into international law, and both discourses, astonishingly, had gone in sort of parallel but rarely intersecting trajectories. And that was a disappointment in one sense, because I thought they could learn a lot from one another. But if you start sort of blending those perspectives, or in this case, blending the kind of the internal and the external, this is in some ways pushing back maybe against what Greg is saying. When you start conflating those two approaches, I do wonder if something is lost. Because, as I said, at least what I find interesting and engaging about international law is very hard to, I mean, you're arguing about the stuff that is the premise of much of social scientific methodology.
One of Adam's points, I think in the last panel, was that, one of the reasons we need lawyers actually involved in this empirical work is precisely for those like careful decisions about what the data is. And I could tell you 100 stories about, bad economists measures, where they just don't take conceptualization and measurement very seriously. So, I think that is kind of a call for interdisciplinary. In any case, sorry, Yifeng, cut you.
Yeah, thank you, John. Yeah, I also would like to very quickly respond to Adam. Actually, I think there's probably a special feature about international law, because international law is, unlike domestic law, has this very strong constructivist function or constitutional function for international law to play. And scholarship is probably as important as the law themselves, because we often need to look at scholarship and what scholar writing to find the law or ascertain the law. I think this is here the constitutional function of international law makes international scholars are very skeptical or very prudent when it comes to those pinpoint examination about rules and the social science approach. And the second thing, I think social science is important, but I also think that when we do social science, we should not just examine if the rule is effective or not in reality. I think we really should conceive the social science also as a political project in unfolding or in organizing society in certain directions. And I think this constitutional function should also be undertaken in the social science approach. In this way, I don't think that social science could be carried out without a normative commitment. I think that's probably too much. So I think international law probably is often oscillating between science and teleology and theology. It's also often related to the faith and its place that we feel that we could transcend our current living conditions by engaging international law. And there's also the sense of probably certain kind of danger that the word of this kind of transcendence might collapse by starting with suspicion or skepticism. I think there's something inherent here. So I agree with some that we sometimes if it is uncertain, we could keep it as it is. But when we try to decipher the word and when we try to look closely, I think we need a certain normative commitment to hold the word together.
Wonderful. Now we're actually up against our time. There are a couple more questions, but maybe what I will do, if it's okay with you, Jared, is just give people permission who need to leave. And Simon and Yifeng, if you have time for 5 more minutes of questions, we could get these on the table. Is that okay? Okay, great. So I'm going to call on Professor Rao to actually unmute and show her face and ask her question, if that's okay.
Sure. Thank you, Tom. So I have a question for Professor Chesterman regarding the point you made about the legal indeterminacy of international law. I was just wondering whether the greater transparency of international organizations nowadays, better access to the views of international law policymakers, and also the digitalization of treaties, negotiating documents, etc., whether these factors make international law, quote unquote, more determinant in some ways now than decades ago. Thank you.
Thanks. It's a great question. That could be the start of a whole conference in its own right. I'll just give a brief response, which is actually linked with something Professor Chen was saying earlier. That, I mean, Professor Rao, as you're saying, there's a lot more data, but one of the reasons for the legal indeterminacy in international law is academics have this outsized role. But the point I didn't make, which is obvious to international lawyers, is you rarely get conclusive answers from authoritative tribunals. So there is rarely a clear answer in the way that most well-ordered domestic legal systems provide at least answers. You may disagree with them, but they provide coherent answers. And one reason for that is not just the structure of international law, the role of international law academics, but the unwillingness of states, and this is what Professor Chen, I think, was highlighting, the unwillingness of states to submit themselves to that kind of regime. And so in the paper, I'll talk about sort of horizontal versus vertical ideas of norms that very, very briefly, in a domestic legal system, you have if you like, a kind of vertical arrangement. There's a sovereign, or at least the idea of a sovereign, and subjects of law. Whereas in international law, the herding cats metaphor is that you've got notional sovereign equality of states. So you get a lot more data, but not more coherent answers, I don't think. There's just a lot more to argue about.
Professor Gatti has a question, and his is really about this internal-external distinction. And I'm just getting to the question about the professional choices we make and how that relate to our methods and approaches, or if that's salient. He was riffing off my Ian Brownlee story, and I think I gave my own answer, but I don't know if you guys have thoughts on professional choices and how those affect us. Greg?
Yeah, I think they definitely do. I mean, the point that you made is those who, have career incentives, that's clearly going to, shape the type of work they do and what they say. I mean, we see this in the confirmation process right now for the cabinet of President Biden. So that to the extent that you have people like yourselves and me, right, who are not pursuing particular careers as an international judge or want to be appointed by the United States to a particular position, it makes it much freer. So yeah, those are part of professional choices. James is making a professional choices as well. We all are. And so I think it may be that, I'm trying to think about, part of me is just saying we need to stop seeing international law as so distinctive. I mean, people who do socio-legal studies of civil rights in the United States or of contract law in the United States, they realize sort of the huge gap between formal law and practice. But part of me thinks that it is distinctive, possibly, in the sense of the outsized role of international scholars, perhaps, the number of them within sort of this, what even called the invisible college or this community. And they do that seems to be something different, right? At least in the US domestic context in terms of the role of scholars and scholarly careers and so forth.
All right, so the last question will be from Mr. Landauer. But it's not typed into the thing, so if you can just unmute and maybe concisely ask your question.
Yes, hi, it's Carl Landauer, and I'm a trained historian, which stands astride the humanities and the social sciences. And I want to ask Simon to go further, but maybe our three authors to go further as well, because I've done a lot of work in the history of the social sciences. And if you think of anthropology, economics, political science, psychology, the formulation or the definition of a social science approach is narrow within each of those disciplines. It's a tiny piece of a very broad and much richer discipline. And so I think that your model is a narrow element of what I see as social science. So I want you to address that and think about that. I mean, think of, for example, what's gone on in anthropology, what's gone on in any of those, psychology, etc., and how much your definition of social science is really very narrow within each of those disciplines.
First, Carl, great to see you. You would, I suspect, be better positioned to answer, at least with regard to the other disciplines. But I'd link it back with maybe something Tom said, which is correct, of course, that the danger of this kind of special pleading is we put the hat on when it suits us, take it off when we don't. We play fast and loose. And I think one of the strengths of this paper, if you like, is that it does force, as a few other papers that it cites does, it forces a serious self-examination about our own methods. Even if you are wary of the social science approach, as I am, obviously, I think you have to be, if the result of all of this is it forces us to be more open about our normative priors, more explicit about our methodology, then the paper will have served a useful purpose. Because I think academics and states, and sometimes academics working for states, are guilty occasionally of conflating those two roles. And I'll wrap up with one final Brownlee story. And it's unfortunate that he's passed away and can't defend himself from this, because I could never actually verify it, which was that in one situation, in one proceeding, I think it was before the International Court of Justice, someone cited an academic article. It was not Brownlee, but someone cited an academic article and was accused of doing a Brownlee, which was that this person had commissioned research that was then published in an international journal and then to be cited in an international court. And this is only possible because of one other structural feature of international law, which is that sometimes disputes can take decades to resolve. So the Lockerbie case, dear to many of us in international law, 15 years and then settled out of court. The articles on the responsibility of states with regard to internationally wrongful acts, the International Law Commission, which is a body we could talk about in terms of the role of academics, took 50 years. 2 special rapporteurs died before they finally produced a report. And so that long time horizon maybe gives academics an additional chance, not just to study, but to influence through their writings the subject matter. But Carl, I'm not really answering your question properly, except to say that, I think you're right that international probably shouldn't claim to be too special. But I do think there is something unusual about international law, unusual about its own regard for its subject matter, that at least makes it worth examining this question differently from the way it's played out in anthropology and other areas. Although the general suspicion of pure objectivity, I think, remains.
Greg or Yifeng, do you have comments?
Yeah, I probably just one very brief point. I think in a way I agree that the idea or the scope of social science defined in the paper is probably very much a restricted one. I think there are many ways of doing social science, and the empirical and data collection is just one way of doing social science. And I think other branches of social science might also inform legal studies. And in a way, I think that there would be also healthy kind of introduction of different methods of social science. Thank you.
Greg, final comment?
Oh, nothing to add to that. I agree. I find it, the paper by you guys, I thought had a narrow definition of social science, which I think you guys acknowledge. But once you open up social science, I think to broader conceptualizations, you also open up the possibility of loosening this internal-external divide.
Well, this whole day has been extremely informative for me, and obviously we're going to refine the paper, but not so much that you have to worry about us undermining your criticisms, which we're really grateful for. We just really are appreciative of everyone for taking the time, for waking up super early, for staying really late, and just thank you all so much. And now I'll turn it back to Nima and Jared if they have final words.
Yeah, absolutely. So just the final word is really just thank you. I just really want to, thank all of our panelists. I'd love to just thank our moderators, Professor Ginsburg, Professor Chilton, for all of your support, not just in the past few weeks, but really the past year, to make sure that this symposium could happen. I also really want to thank Jared Mayer, who did a lot of behind-the-scenes work in organizing this event and coordinating with the scholars. And I also want to thank a few folks who have been working behind the scenes to make this a success, including Tyler Downing, Alexandra Short, our Assistant Director of Events here at the Law School, and Claire Perrins, the Director of Academic Publications. As I stated at the top, the contributions and discussions from today are going to be memorialized in the 22nd volume of CJIL, which will publish early this summer. And so with that, thank you again to everyone who was here today.